Our next case is People versus Montez. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and you have an opportunity for rebuttal. We ask that if you're going to reserve time, that you keep track of that yourself. You may begin when you're ready.
Thank you, Your Honor. Good morning. May it please the Court. Maya Menlo of the State Appellate Defender Office, appearing on behalf of Mr. Montez. With me at counsel table is Jessica Zimbelman. I would request 3 minutes for rebuttal, and I will keep my own time. The pre-sentence investigation report is the fundamental document used by the trial court at sentencing. In People v. Triplett, this court said that the PSIR is of pivotal significance in sentencing decisions. A defendant cannot waive the PSIR, and the judge must consider the PSIR before imposing or accepting a sentencing agreement, and of course, before imposing sentence in any case. Beyond sentencing, the PSIR impacts programming and security classification in the Michigan Department of Corrections. The parole board relies heavily on the PSIR when it's considering a person for parole. Because the PSIR is so critically important at so many stages, Michigan statute, case law, and court rules require that the information in the report be relevant. Any irrelevant information must be struck from the report. This court's decision in People v. Beck made acquitted conduct irrelevant at sentencing by holding that a sentencing court cannot rely, even in part, on acquitted conduct. And since acquitted conduct is irrelevant, it must not appear in the PSIR. This court should issue an opinion holding that the PSIR may not make reference to acquitted conduct. I welcome the court's questions at any time.
Counsel, would you have, if the PSIR had been, I guess, a little more sparse in details on the acquitted conduct, would you agree that some context would have been appropriate in here? I mean, was there any, from your perspective, could it be mentioned at all?
No, Your Honor, because it's not relevant at all to the sentencing decision. The convicted conduct is what the trial court should be assessing in sentencing the defendant, not any acquitted conduct whatsoever.
I mean, I can see the sort of narrative. PSIRs often have a narrative about how this conduct was discovered and the investigation and the background. And obviously, there was an investigation. The allegations that resulted in the acquitted conduct led to the investigation of the other sibling. Does that matter?
I can't think of a reason why that would be relevant to a sentencing court's determination of how to punish an individual for the convicted conduct. So
Could
no.
there be a time where maybe it's relevant? I mean, I understand the argument here. It potentially could be separated, but we see acquittals where maybe there's an acquittal of a gun charge, but they're charged with something else, and yet maybe the gun, the allegations of the gun are an important part of the narrative. Could that be included?
I understand the interest in a complete narrative, but following Beck, an individual's due process right outweighs any concern about narrative. And so I have to stay strong on that, Your Honor, and say that no, it's just not relevant to punishing the convicted conduct, that there was something else in the ether, some other allegation or some matter that has been put before the jury and that the jury rejected.
Thank you.
A helpful analogy in this case that's raised in my brief is to the inclusion of convictions that were obtained in violation of Gideon. In the Tucker-Moore line of cases, this court and the Court of Appeals have said that those convictions cannot appear in the pre-sentence investigation report. And so where they're erroneously included, then this court and other courts have remanded for their removal.
Can you, assuming we disagree with those reasons, can you talk, I think you've made the argument in your, maybe it's the supplemental reply, that there are other consequences to including, whether it be acquitted conduct or just conduct perhaps that wasn't charged or whatever, in, here we'll stick with acquitted conduct, in the PSIR, even if it's not relied on by the sentencing judge.
Certainly, yes, Your Honor. There is prejudice to Mr. Montez as far as his chances at parole, his programming while in the Michigan Department of Corrections. I used an example in the brief of someone who might be convicted of a crime that doesn't involve any sexual component and then is acquitted of a CSC, for example. And that person, if the CSC is referenced in their PSIR, is very likely going to be required to participate in the Michigan Sex Offender Program in the Michigan Department of Corrections. And that program requires, in order to successfully complete it, what amounts to an admission of the sexual conduct. But in my example, that person has been acquitted of that sexual conduct.
Well, and that wouldn't necessarily apply in this case.
That's true, Your Honor.
Because there is the convicted conduct is a CSC as well. But and not discounting that as being a legitimate concern of including information in the PSIR that should not be there, is the remedy for that when, not in reviewing the sentence, but when that actually materializes and causes harm, say, to somebody but for the fact that they can't get CSC or sex offender programming that they shouldn't have had to have, they would have been eligible for parole.
I understand the question. Mr. Montez is entitled to and has the best opportunity to challenge the contents of his PSIR now on direct appeal. And the Court of Appeals in People versus Lloyd laid that out. Of course, our statutes and court rules entitle him to make those objections. And I'm not aware of any case in any court where the remedy, or there was no remedy, where there was something improper in the PSIR and the court recognized that. The remedy is at least to remand, to remove those references to whatever it is that's improper.
Is that relief that you're seeking? Is that if not to, remand for resentencing, but to remand to remove the references?
Yes, Your Honor. If not resentencing, then certainly this acquitted conduct has to come out. If there are no further questions at this time, I'll reserve my remaining time for rebuttal. Thank you.
Thank you.
Good morning. Audra Blodgett appearing on behalf of the people. May it please the court. The references to acquitted conduct in defendant's PSIR gave accurate and relevant context to the crime of which he was convicted. Inclusion of these details does not violate Beck as long as defendant was not sentenced based on this acquitted conduct. Here, defendant Montez was not sentenced based on acquitted conduct. When the full sentencing transcript is reviewed, the court repeatedly stated that it was sentencing defendant based on a single conviction of criminal sexual conduct with one victim, N.E. The sentencing court's observation that defendant's actions impacted a number of people very significantly was not referencing the acquitted conduct against A.E. But during trial, the court heard from 3 404B witnesses detailing the sexual abuse they had suffered at the hands of defendant. 2 of these witnesses were present in the sentencing courtroom and stood before the court to make a statement about the long-lasting effect of defendant's abuse. The court's comments about the impact of defendant's actions were acknowledging these victims, which is a proper sentencing consideration. To find error in this case, defendant asks this court to hold that only information that can properly be relied upon at sentencing appear in the report, which would exclude all mention of acquitted conduct. But this rule is overly broad and unworkable. With such a holding, the PSIR would no longer provide fully accurate and relevant narratives. It would be unable to explain inconsistent jury verdicts. It would lead to the censoring of victim impact statements. Nor does it offer any great benefit to defendants, whose protection against being sentenced on acquitted conduct is already adequately safeguarded with existing case law and appellate review. For these reasons, the people ask this court to deny the application and affirm the Court of Appeals. I'm open to any questions.
Counsel, what is your response to defendant's argument that there's concerns about how the PSIR can be used later? But, assuming I agree with you that Judge Sullivan did his job well here and didn't rely on it, there's this, concern that could arise later, years later, that a CSC defendant who let's assume, I understand in this one, we have the conviction and the acquittal, both CSC charges, but let's assume it's not that. Let's assume there is no CSC conviction and the defendant's been acquitted but charged with something else, goes to prison for that. There's this sort of concern that the report will be used to require, sex offender treatment programs, and they can't get out on parole until that's done, and there's a long list to get on that. How do we handle that?
Sure, I think it is primarily first guarded by the case law that says, even the parole board is prohibited from considering acquitted conduct. The PSIR as an entire document many times says what your charges were, what your convicted conduct is. So I do think you have to acknowledge that the entire document provides the context that would prevent that from happening. I would also flag that there are cases where defendants are sentenced to sexual predator programming in MDOC without having a CSC conviction, just through their assessment, their COMPASS assessment, their interviews with the probation department, parole board. So I don't think that this problem would be solved by eliminating acquitted conduct from the PSIR. Instead, I think doing that would create more problems, including, like I highlighted in my opening, creating problems for defendants who may want to reference acquitted conduct themselves. And I would pose a hypothetical to the court to illustrate both the benefit to defendants to keeping this conduct in and to address Justice Welch's hypothetical of what happens when there's overlapping conduct. So in this hypothetical, a fight happens at a bar. The police have probable cause to arrest the defendant who resists arrest. At trial, if the jury acquitted him of the assault after the witnesses said they were largely too intoxicated to remember what happened, but convicted him of the resisting arrest charge. To prove resisting arrest, the legality of the arrest would be a factual element for the jury to decide, to find beyond a reasonable doubt, even if the underlying assault was not proven. In this case, the underlying facts to the arrest would not be able to be referenced, why the police showed up, what he was resisting arrest for, the fight at the bar. When a defendant comes before the parole board, perhaps he wants to reference that I'm not a danger to the community at large. I resisted arrest because I, in this exact situation, thought I was being unlawfully detained. So I think by a blanket rule preventing the assault and the jury verdict from being mentioned by anyone, it would create problems for not only the parole board, the prosecution, the trial judge, but also defendants who may want to use these facts to their benefit at parole. I would also highlight that at parole, to Justice Welch's question, anyone, a prosecutor, a victim, an interested community member, can submit trial transcripts of what happened at trial to the parole board to consider. So if this rule were to take effect, it wouldn't have as much bite, or it is a bit overblown to eliminate it from the PSIR, because this information would be presented to the parole board via transcripts or other victim impact statements. So I think by creating such a broad, unworkable rule, we aren't even preventing the danger that they seek to prevent. And I think there are two issues before the court in this case, not only this broad rule that they propose to eliminate acquitted conduct from all PSIRs, but also if there's error in this specific case. I think I highlighted in my opening why we think that the judge's comments were clear, that there was a single conviction and single victim. And so there was no error for the trial attorney not to object at sentencing. Under the law as it stood, the conduct was relevant to the context of the case, to how the judge was reviewing the facts of what was disclosed to CPS and to law enforcement. And requiring the trial attorney to object for acquitted conduct being included in the PSIR would be a futile objection. Under Beck, that was prohibited, and under Stokes, that was affirmed. Seeing no other questions from the court, I would rest on our brief and ask that the Court of Appeals be affirmed. Thank you.
Thank you.
I'd like to first address the question of reliance on acquitted conduct in this case. It's an interesting one where we're talking about the pre-sentence investigation report because there is so much law that says the judge can and must rely on the PSIR. So there is inherent reliance on the PSIR, and I think that makes this unique. There's case law, including in Grant from this court, that talks about that. We also, though, here have some evidence, some indication of reliance on the record. I don't think it's clear that the judge was talking about some victims and not others. He uses the word victims, and that's significant. There's no disavowal on the record about what I am sentencing you based on and what I am not. There's no indication that, yes, there's acquitted conduct in the PSIR, but I'm not relying on that. That's not present in the record here, so that should be cause for concern. And then the trial court sentenced Mr. Montez to the top of the guidelines. So even if this court requires something on the record to prove reliance, we do have indications here.
Counsel, does it matter? Does it make a difference that it's, I believe, the same judge who had the trial who's now looking at the PSIR? I mean, presumably the judge remembers there was an acquittal. So does that factor in?
It's interesting that you say that, Your Honor, because I think that's an excellent point that the judge would remember that, and so therefore there's no need to, as the prosecutor argues, include mentions of acquitted conduct in the PSIR to remind the judge that there was an acquittal. So I think it's really unfair, actually, to include this conduct in the PSIR, to tell the court that it can rely on the PSIR, and then they can't do that, right? So it's unfair to give them all this information and tell them they can rely on it, but then we have law that says they can't. I just want to respond to the prosecutor's hypothetical. The narrative in the PSIR in that case could fairly say that the jury found there was probable cause to arrest because the jury would have found that as an element of resisting and obstructing, that it was a lawful arrest. So I don't think that, I think our probation agents deserve a little more credit that they can craft descriptions of the offense that comport with the Constitution. And a rule from this court would really help them with that. It's also worth mentioning that transcripts of acquitted conduct are not proper considerations for the parole board. The prosecutor made that argument, but there's binding case law of the Court of Appeals, Adams versus Parole Board, which is cited in my brief, that clearly says no acquitted conduct can be considered in parole determinations. And so again, unfair to put information in front of the parole board that it is by law of the Court of Appeals forbidden from considering. If there are no further questions, I will rest on my brief and thank the court for its time.
Any other questions? Thank you both. The case will be submitted.
Thank you.